Okay, I'm going to go ahead and get started. Welcome. Happy Saturday morning. I am coming to you from Japan. Not really. I was in Japan this summer, and that's just a fake background for that. I'm getting ready to go work out this morning, and so I'm in my workout gear. Apologize for being a little less professional with that, but I guess you guys can tolerate that. I'm going to go ahead and share my screen here with you in just a minute. You probably probably won't do you a lot of good, but it's better than looking at me for the entire time with some of my notes that I have prepared for real estate one and real estate two. Remember, this is a video. The first half of it will be for the next exam. The second half of it will be focused on the new material for the second exam. And I say the new material for the second exam intentionally. And the reason I say it that way is because it is cumulative. You can have questions on the second exam that come from and build upon material that you learned in the first exam. I just divided the section into two different weeks because there's a lot of material in real property one in real property, and so I made it real property one and real property two. It can be confusing as well, and most of you are doing very, very well in the class at this point, and I don't want you to mess that up with real property. So I have it in two different weeks. Okay, I'm going to go ahead and get started with sharing my screen. Let's see. Okay, that should do it. Again, it probably won't mean a whole lot to you, but it will keep me on track. Real property one or real estate one. You need to know, what constitutes your rights in property. Lots of people that haven't had legal training don't understand what the difference is in what your property rights are. What is it called if you own all the property rights in a particular piece of property? What rights do you have? Do you have the rights under the ground, on top of the ground, growing from the ground, above the ground? Some of those you do, and some of those you do not. So, just be sure that you understand which ones that you do have. What happens if you have less than full ownership? What is it called? What's a leasehold interest? What's a life estate interest? What rights do you have in those instances where you have less than full ownership of the property? What if you have less than full ownership of the property and you do something to the property? Can you damage the property? Can you sell the property? Can you mortgage the property? Can you borrow against the property? What if you install things to the property? What happens with those fixtures? Does it differ if you are a residential occupier of that property versus a commercial occupier of that property? Um, what if there's more than one person that owns interests in the property at the same time? Now, if you have a leasehold interest, you that's an example, but that's not the only example. You have examples including things like co-owners with that are joint tenants. Either the two primary means in the state of Alabama, at least, are joint tenants with rights of survivorship and joint tenants in common. Are those divisible interests? Are they what happens if someone passes um, and they own a joint tenancy with right of survivorship interest? What happens if someone passes? And by passes, I mean, of course, dies, and they have a joint tenancy in common interest? Um, Does it pass by their will or by intestacy, or does it pass according to the terms of the deed? And it differs depending upon the type of deed that you have. And it's going to be important for you to understand that and recognize that. Maybe not on this exam, maybe on the week after, and maybe on this one, and maybe on the week after. What's the difference between a profit interest and a license interest and an easement interest? You need to know the differences between those things so that if I give you a fact pattern on the exam, you can recognize it and you can identify it. Um, what does it mean if we're in a community property state? Almost everybody messes this up who hasn't been legally trained as it relates to the state of Alabama. They're used to hearing things like, oh, gee, those people got a divorce, or maybe you got a divorce, and the property was community property. We are not a community property state, not for real estate purposes. Domestic law, family law, they use the term in a different way. It's not a real estate type concept. There are some states, um, I don't recall, maybe a dozen states or so, that are community property states in the United States. One of them is Louisiana. That's the closest one to us. Alabama is not one of those. What happens if you own property in a community property state and then you move to Alabama? Does it change? What, you need to know that. Um, and my note there, lay people understanding will cause incorrect answers in this area. I can always tell people who haven't studied when it comes to questions like this because they're guessing, and they give answers that indicate they had a layperson understanding, and it's almost always wrong when that happens. Okay, there's your little 10-minute capsule, maybe a little less than that, 10-minute capsule of real estate one. Now let me stop the share for a minute because I need to pull over and grab something else, and I'm going to go into real estate two. We'll share the screen again, and there we go. Um, okay, real estate two. Again, this is building upon real estate one. And so don't forget the information, the material, the things you studied for this coming week's quiz, because it will be on the quiz that follows as well, or potentially will be. In fact, as I've mentioned several times, the entire class is cumulative or comprehensive in the sense that anything we've covered is fair game for a future exam. Now, it's not common that I'll pull a Fair Credit Reporting Act question on a real estate quiz, but I could. It's more common that I would give you an example of a real estate litigation matter, and it may contain things from the courts and alternative dispute resolution chapter or week that we covered material on that. And you'll have to know, in order to get the real estate question right, you'll have to know things that we learn in the courts and alternative dispute section of the class. Okay, real estate two, some specific things that, and again, this doesn't mean this is everything on the quiz at all. These are just things that I find important, or things that I know you need to know, or things that are sometimes a little tricky and you need a little help in guidance in moving forward toward learning this stuff. Um, the statute of frauds. I'm going to start there because it was introduced this current week, and it continues for the second week. The statute of frauds, it's statute of frauds, Statute. You may not be able to read my handwriting very well there. It's not a statute. It's not something that's, the Statue of Liberty. It's a law. The statute of frauds is a law that is in Alabama as well as every other state that I know of in different forms. And it says that, well, in order for certain contracts, and we're going to hear this again when we get to contract law. We're going to be tested on it again when we get to contract law. We'll learn more about the statute of frauds there, but this is a good place to introduce it. It says in order for some contracts to be valid, the um, the contract must be in writing. In other words, we're not going to legally enforce a verbal contract in some cases. Because, a lot of people don't know, and we'll talk about this more later, but a verbal contract is a contract. If I offer to sell you my car for $1,000 and you agree to pay $1,000, we've got a contract. It doesn't have to be in writing for it to be enforceable. You could sue me if I don't sell that to you. I could sue you if you don't pay me. It's still a contract. It's a valid contract because it does not fall within the statute of frauds. Well, matters involving interest in real estate, in real property, must be in writing in order to be legally enforceable according to the statute of frauds. That's all. That's really all that was required there. Types of deeds. The main types of deeds that I generally test on are warranty and quitclaim deeds. Which one conveys good title? Do both convey good title? What if good title isn't obtained in a warranty deed? What if good title isn't obtained in a quitclaim deed? What interest do you convey if you're selling if you use a quitclaim deed? What interest do you convey if you're selling if you use a warranty deed? What interest do you obtain as a buyer if you obtain it via a warranty deed? What interest do you obtain as a buyer if you obtain it as a quitclaim deed? Um, know generally the process that is involved in a sale or a transaction involving land. You have a purchase and sale agreement. You have a deed. Which one actually transfers legal ownership of the property? What comes first? What comes last? How does the process go? Um, in the event that you have a less than full ownership type interest in land, and such as a leasehold interest in land, and you have a lease, even if it's a written lease, are there any other rights that are protections that you have if it's not contained in the lease agreement itself? Are there any covenants that may exist? Uh, Talk to me about or understand about the covenant of quiet enjoyment. What does it mean? The covenant of or implied warranty of habitability. What does that mean? What if the lease doesn't provide anything related to the a house, for example, and it's infested with vermin? Are there any protections? You got a lease. And as we will learn when we get to the contract section, the contract is the law between the parties, but are there exceptions? This is law. We've talked about all semester long. Law is nothing but exceptions. We have a general rule, and that's what a lot of people know if they know anything about law and they don't know the exceptions, and you need to know what the exceptions are. Leases. This is sort of important for a lot of you in a certain age group and attending college and maybe going out of town to go to college. You lease property. What happens during the summer? You're not taking classes, you're not living there. Can you assign the lease? Can you sublease the lease? If you, what if, do you have to have the rights listed in the lease to do either one? If you sublease your interest in the lease, what happens to the obligation to pay the lease? Do you still have it? Does the new tenant, the subtenant, does the subtenant have it? What if instead of assigning the lease, you actually just sublease your interest? Are you still on the hook, or does it get you off the hook with the landowner? If so, what happens if the subtenant fails to pay the lease? Are you obligated to pay? What interests and what rights do you have to be protected in the situation like that? Um, the sale of property. General rule, and I'm not going to try to teach it here, but you need to understand what the principle of caveat emptor means. You know, it means let the buyer beware, but what does it mean as it relates to the sale of real property in the state of Alabama? What are the exceptions to caveat emptor, or are there any exceptions? Is it an absolute let the buyer beware kind of thing? You don't ask, we don't tell kind of situation. You need to know that, because I can assure you, you're going to have a question on that or two. Some of the material that will address that. Eminent domain. Gosh, this is something that I don't think is that complicated, but based upon the answers and the questions and the results from prior classes, it seems to be something that students struggle with. Um, so I'm going to try to spend just a couple of minutes here and talk about it to maybe help you in your studying for this. And if you haven't studied sufficiently by this point for this topic, please go back and look at it again. Um, Eminent domain is the power of the government to take property. And that power is not absolute. There are certain requirements for the government to be able to do that. They can't just look and say, gee, we like your house, we're going to take it. What they can do is they can look at property and they can say, you know, gee, we have a valid purpose for the public that will serve the public good. And unfortunately for you, your property is part of that property that we need in order to serve the public good. Now, they can't just take it, but that's step one. That's kind of the first prong for it. It serves a public purpose. They can't just take it for any reason. It must serve a public purpose. Now, I will be honest, I think the Supreme Court has extended the public purpose beyond what the concept really was intended to cover, but it's still there. There still must be a public purpose that is served by the taking of the property. Prong one. Two prongs must be met. That's prong one. Prong two is that something called just compensation must be paid. And it's something similar to fair market value. It's not fair market value, but it's similar enough that for our purposes for discussion, we can think of it that way. So both things must occur. What if the government comes in and says, "Hey, your your land is worth $100,000. We need your land in order to build a new public health facility, um, and um, and so we're going to take it. Here's $50,000. Is that sufficient? Should eminent domain be allowed in that case? Well, the answer is no. Yes, it's for a public purpose. Yes, they paid you some compensation, but $50,000 for property that's worth $100,000 is not just compensation under the circumstances. What if they come by and they look and they say, "Gee, we like your land. Um, we don't know what we're going to do with it, but we like your land. At some point in the future, we might use it for something good. Your land's worth $100,000. We'll pay you $100,000, or we're going to pay you $120,000." Surely that meets the definition of just compensation. Can eminent domain apply in that situation? Well, yes, just compensation was met in that circumstance. However, I told you this was a two-pronged test. You must meet both tests in order to prevail in the situation involving eminent domain. And when I say, prevail, I mean for eminent domain to apply. The government must not only pay just compensation, but it also must take the property, the taking of the property itself must fulfill a public purpose. And just grabbing property just to grab property doesn't fill that need. As I said, I think it's been extended beyond where it should. There's a case involving up in the Northeast uh, community that took property in order to build a new shopping mall where they argued that, well, and the community didn't build the new shopping mall. They sold it to a builder who built and put in a new shopping mall. So the community took the property in order to fill the public purpose of selling it. That's not really a public purpose. That's just doing business. What they argued successfully, I think the Supreme Court was wrong, but what they argued successfully was, well, the people we sold it to, now they were going to build a shopping mall, and in that shopping mall, they were going to hire bunches of people, and those people were more than likely going to be people that were in the community. So we were serving a public service, a public need with that. I think that extends it beyond where it was intended. I don't think that was a good decision. I think there the facts made bad law, but they are what they are. Nonetheless, public purpose is still part of it. In any event, hope this has been helpful. Good luck with the next two quizzes. As always, if there's anything I can do to help you in the class, please let me know, and I will see you next time. Thanks.